Good evening. Tonight we will discuss four things. We will discuss the process of disbarment procedurally, as observed in the Supreme Court and as observed in the Integrated Bar of the Philippines. Secondly, we will discuss the readmission or reinstitution to the practice of law. Thirdly, we will touch upon the mandatory continuing legal education. And then lastly, we will go through judicial ethics very shortly. We'll just focus on those important things involving the offenses of judges and the disqualification of judges. A proceeding for disbarment, suspension, or discipline of lawyers may be instituted by two ways. It may be taken up by the Supreme Court by virtue of its own instance, motu proprio, or it may begin through a verified complaint filed before the Integrated Bar of the Philippines. In the Supreme Court, a an action against an erring lawyer may be made by the Supreme Court because of its own findings. There is no need for a private complainant in this case. One of the recent cases in which the Supreme Court exercised its administrative power over court personnel is this case, right? Decision dated 17 for the case People versus Barroso. In this case, a certain fiscal was convicted for bribery. But just because a lawyer has been convicted of a crime, even if this crime involves moral turpitude, disbarment does not follow. Now, this lawyer, after some time, wrote a letter to a certain international company demanding payment for a certain violation of labor rights. This company investigated this lawyer and wrote a letter to the office of the bar confidant asking if it is still connected as a public official or as a fiscal, as it found out that this lawyer has previously been convicted. In this case, the Supreme Court itself instituted a disbarment procedure against this erring fiscal. It noted that the fiscal was a member of the judiciary, was a member of the judicial functions in delivering justice in the country. He's a member of the DOJ. I'm sorry. He's not a member of the judiciary. When he committed this crime of direct bribery. Thus, he was found to be unfit for the practice of law and was disbarred. If there is a filing of a verified complaint, Before the Supreme Court will transmit it to the Integrated Bar of the Philippines. But for purposes of clarity, a verified complaint is a document in which the facts of the violations committed by the lawyer are clearly and concisely stated, and the evidence supporting these allegations are attached thereto. Now, when the Supreme Court institutes an investigation, institutes a disbarment, suspension, or discipline procedure, it may refer the case for investigation, either to the Solicitor General or to any officer of the Supreme Court or a judge of lower court. The Supreme Court deals with these kinds of cases as disbarment, suspension, or discipline of lawyers in a very straightforward manner. It forwards its motu proprio findings and refers it for investigation again to any member of the Supreme Court, to the Solicitor General, or any judge of a lower court. The investigation must be made with deliberate speed. Now, after the investigation has been finalized, the investigator must submit a recommendation within 30 days from the finalization of the investigation. Now, this recommendation will be subject to the final action of the Supreme Court. Of course, the Supreme Court is not bound by the findings in the investigation, although it takes note of the findings thereof and gives it sufficient faith and credit without showing any grave anomaly in the investigation, as in a certain case where the lawyer was not given the opportunity to defend herself. The Supreme Court will give due credit to the findings in the recommendation. Nevertheless, the decision rests with the Supreme Court. Notwithstanding the findings, the Supreme Court may dismiss this case or may impose penalties as may be proper. Now, let's discuss the powers of the investigator. The investigator has the power to issue subpoenas and administer oaths. So the investigator has a compelling power to obtain the necessary evidence that are instrumental to this case and to ensure that all the allegations that are made therein are true and correct according to the knowledge of the person alleging these facts and circumstances or defenses. Now, it is a right of the respondent to defend himself or herself fully. But if the respondent has been notified of the proceedings and has been required to submit, let's say, the answer, but fails to file the answer, fails to appear on the date of the proceedings, the investigator deems that the respondent has waived this right to file the answer or to defend himself by appearance. Now, if there are willful failures or refusal to obey these mandatory orders of the investigator, these violations would be tantamount to indirect contempt. So, herein, after the submission of the recommendations, along with the findings of fact, it is still the Supreme Court who will decide on the matter, whether to dismiss the case, impose penalties, or to remand the case for further deliberations, further investigation. Now, let's go to the procedural steps for investigation in disbarment proceedings, suspension proceedings, or discipline proceedings in the Integrated Bar of the Philippines. Please take note that even the Integrated Bar of the Philippines may institute these proceedings motu proprio or upon a verified complaint. The first thing that they will do is appoint an investigator. This investigator would be any member of the IBP. In certain cases, there are even 3 investigators. So they act as a panel. Now, if the complaint is found to be with merit, the respondent would be provided a copy of the verified complaint or the motu proprio findings and required to submit an answer within 15 days from service. Now, an investigator may also be disqualified. How? If the investigator is related to any of the parties or the counsel of the parties. If the investigator has a pecuniary interest on the case or a personal bias or in carrying out his duty as an investigator, he let's say voluntarily or inadvertently acts as counsel for one side. If the investigator has violated this, he must inhibit himself. Or if he is not qualified, he must inhibit himself. If he does not, the party to the case may be allowed to file an appeal before the IBP Board of Governors. Because the IBP Board of Governors may remove the investigator, but only for cause and after due hearing by a majority vote. Now, if there is no appeal before the IBP Board of Governors, the vote requirement is increased to at least 6 members of the IBP Board of Governors. So, during the investigation, the respondent may or may not file an answer. Okay? If he files an answer, then the answer will be considered. If he does not, then the answer will be deemed to have been waived. The right to file an answer will be deemed to have been waived. Okay, so after the filing of the answer, there will be a consolidation of the information which were obtained through the investigation. The investigator will consider the allegations in the complaint and the defenses raised in the answer. Now, if there is no answer, there is no problem because the investigator may issue subpoenas or anything that he may need. As always, the respondent is given the full opportunity to defend himself. Now, uh, the investigation has a timeline. It should be finished within 3 months from the commencement of the period, from the commencement of the action. I'm sorry. Okay. Now, this period may be extended for justifiable reasons. Next, upon the finalization of the investigation or after 3 months from the commencement of the investigation, the investigator must submit a report of his findings and recommendations to the IBP Board of Governors. The IBP Board of Governors has the power to review the recommendation of the investigator. You see, the power to review includes with it the power to approve, to deny, to modify, or to remand. There is also a timeline uh, for the review of this recommendation of the investigator by the Board of Governors. The Board of Governors must decide on the case according to the findings and the recommendations, not exceeding 30 days from the next meeting of the board following the submission of the report of the investigator. Ano to? Uh, you see, the Board of Governors do not meet frequently, but they do have regular meetings. Ngayon, yung findings and recommendations may be submitted at any time. At any time. The timeline for the decision of the Board of Governors is not upon the submission of the findings and recommendations by the investigator. It is dependent on the meeting of the Board of Governors. Now, if the report has been submitted, you wait for the meeting of the Board of Governors where it will be dealt with. Kahit regular meeting, kahit special meeting. There are two things which may happen sa Board of Governors. It is either they dismiss the case or they resolve to transmit it to the Supreme Court for final action. So, the IBP has no power to impose penalties. It is only the Supreme Court which has been constitutionally granted the power to discipline its administrative employees or the administrative employees of the court. Okay. If the IBP decides to dismiss it or exonerate the respondent, then the case will be dismissed. Upon dismissal, however, the complainant or the aggrieved party may file an appeal within 15 days from notice of the board's decision. In disbarment proceedings in the IBP, we begin with either a motu proprio finding or a verified complaint. Now, as to a verified complaint, it is first determined by the investigator if it has merit or not. If it has merit, then the investigator will require the respondent to file an answer within 15 days from the date of service. And then, upon the filing of the answer or the failure to file the answer, the investigation must proceed with deliberate speed. We have noted that there is a timeline. The investigation must be completed within 3 months from the commencement of the action. This period may be extended for justifiable reasons, but as a general rule, 3 months from the commencement. Now, upon the termination of the investigation, the investigator must submit his findings and recommendation to the Board of Governors. Now we look at the right side. If at the start, the verified complaint has been found to be without merit, the investigator will recommend a dismissal of the case. The investigator cannot dismiss the case. He can only recommend the dismissal thereof. The same is true if the respondent files an answer and the investigator in his findings initially in determination of the answer finds that there is no merit to the verified complaint. In this case, the investigator will also recommend the dismissal of the case. These recommendations and findings will be submitted to the IBP Board of Governors, who must decide on the case within 30 days from the last meeting that they held in which the findings and recommendation of the investigator have been submitted. If the IBP Board of Governors resolve to proceed with the case, they will uh, create a resolution and transmit it to the Supreme Court. If the IBP Board of Governors decides to dismiss the case, they will create a decision and exonerate the respondent. Cotton versus Liza is a case where the Supreme Court found out that the respondent was not given the chance to fully defend herself. There was no mention of her participation in the investigation. Ang decision dito, remanded for investigation again. Ibinalik ng Supreme Court sa IBB Board of Governors. Now, as to a motion for reconsideration, mahalaga kasi yan. You will find out later on that every decision, every order may be a subject of a motion for reconsideration unless it is prohibited. And generally, konti lang yung prohibited yung motion for reconsideration. In cases like this, hindi ka pwedeng mag-motion for reconsideration sa findings and recommendations ng investigator. Saan ka mag-motion for reconsideration? Dun ka sa either resolution ng IBB Board of Governors or sa decision ng IBB Board of Governors to dismiss or exonerate. Ano yung motion for reconsideration? You make them look at it again and reconsider the facts and the findings and the evidence. You may even introduce new evidence, newly discovered evidence only in a motion for reconsideration. So, ngayon, itutak nyo na kagad pagka sa investigator, wala pang motion for reconsideration, pero sa IBB Board of Governors, may motion for reconsideration. Okay. Modifying circumstances in disbarment cases. Kala ko sa criminal cases lang to. Meron din pala sa legal ethics cases. There are also modifying circumstances in disbarment cases, which include mitigating circumstances, aggravating circumstances, and a so-called neutral circumstances. We will discuss each of them briefly. We look at the IBP guidelines for imposing lawyer sanctions. We see that there are modifying circumstances that are considered in imposing penalties or sanctions. Here are some of the mitigating circumstances which are detailed in jurisprudence and also in the IBP guidelines. Lawyers are prohibited in acquiring the property of their clients. Meron yan na ang bayad lupa. Pagka ang acceptance fee niya lupa. May mga ganyan. Lalo na sa probinsya. But that's prohibited. Now, if there is good faith in that transaction or acquisition of property, it will be considered by the Supreme Court as mitigating. Paano yung good faith? There may be circumstances where the property has been transferred several times already, but ends up in the ownership of the lawyer who was counsel for the previous owner way back. Ito ang favorite excuse ko in experience of the lawyer. At pwede ko pang gamitin yan. Age is too young, a mitigating circumstance. Too old. Pag too old ka na, mitigating na yan. Apology. You will see in disbarment cases, in reinstitution to the practice of law cases, that this is one of the most important things in facing disciplinary proceedings, disbarment proceedings. Remorse is also considered. Of course, we will not go through them one by one. You should check 9.3.1 of the IBP guidelines for imposing lawyer sanctions. Kulang pa kasi to. But surprisingly, it even includes personal or emotional problems. Pag broken-hearted si attorney, mitigating pala yun. Aggravating circumstances. Ano to? We include prior disciplinary offenses. If there are other disciplinary offenses which the lawyer has already faced, even if the lawyer was exonerated, there will be a question hanging on the mind of the investigators, of the IBP Board of Governors, of the Supreme Court. Why is it that this lawyer faces several disciplinary cases? If it is also found out that the lawyer harbors dishonest or selfish motives in the violation, it will be aggravating. A characteristic of being unfit to the practice of law would be displayed by recurring violations. So if a pattern is already forming in the misconduct of the lawyer, then it is aggravating. Multiple offenses, bad faith, submission of false evidence. Ito, meron tayong case na i-discuss regarding it. Refusal to acknowledge wrongful nature of conduct and others. Meron din tayo dun sa indifference to making restitution. Now, there are cases which are neither aggravating nor mitigating. This is not legally termed as neutral circumstances. It's just personal coinage. Now, how can it be aggravating or mitigating? We noted that a restitution, remorse, apology may be mitigating. But if it is forced or compelled, napilitan lang, then it will serve as neither mitigating or aggravating. You see, in disbarment cases, lawyers often just want to get out of it. In disciplinary cases, they just want to get out of it. So there may be a tendency where the lawyer agrees to even improper demands by the complainant. If the private complainant who submitted the verified complaint withdraws from the case, the case will proceed. Similar with the criminal cases. It is because it is the interests of the public that is at stake. Okay, ano pa ba yung mga neutral circumstances? Resignation. Let's say that the lawyer is a public officer. His resignation will not affect the case. If the complainant barters for the sanction, sabihin niya, ano na lang, warning na lang po yung sanction ko, warning na lang. O suspension na lang po yung sanction ko, reprimand na lang yung sanction ko. It will not work like plea bargaining. Yung tipong mag-a-admit na lang siya, oo, ginawa ko yan, pero ito na lang sanction ko, inamin ko naman. Another neutral circumstance is the failure of the injured client to complain. Kahit sino kasi yung mag-file ng verified complaint. Kahit hindi yung victim. Next, we will discuss reinstatement to the bar. Briefly. I'm sorry, we do not have a lot of time. The Supreme Court may again give another chance to erring lawyers. But the court, as cited by Ke versus Revilla from the case called versus Kentucky, the court owes it to both the public and the legal profession to ensure that if a lawyer will be readmitted or reinstated, it is because the lawyer is fit to practice law already. These are the guidelines which have been issued for the exercise of judicial clemency. I strongly suggest you memorize them. Not because you will be facing these kinds of cases, but because if you know these guidelines, solved ka na sa reinstatement subject. First, there must be proof of remorse or reformation. Remorse. This is a quality which is wanting from a lot of lawyers who were disbarred and are asking for reinstatement. The judge in this case allege that the judge has learned his lesson. But this mere allegation cannot be perceived in any manner as remorseful. There was also no proof submitted by this judge that he has reformed his ways. Usually, what is submitted as proof of remorse or reformation are attestations of other persons. They claim that the person who was disbarred is already a new man, a new person, a new woman. Even if these claims come from uh, high ranking officials, come from religious personnel, there must be a separate, some separate evidence whereby it is proven that the erring lawyer has been reformed and is remorseful because of the acts which she committed. Now, there is this case that we will discuss later on, Torres case, where after the disbarment, he filed several motions for reconsideration and then filed and filed again. Ang sipag niya magpa-reinstate. Nevertheless, the Supreme Court requires a period of reformation. It's not only 1 year, 2 years. You have a lawyer must reform his ways. Thirdly, lawyers must show or prove to the Supreme Court that if he is reinstated or readmitted, his privilege to practice law will still be of benefit to the public, will still be of benefit to society. I'm sorry, excuse me. Lastly, uh, there must be a showing of promise. The lawyer, the person who will be reinstituted or readmitted, must have uh, something that he will contribute for the benefit of the society as a lawyer and for the benefit of the legal profession. This includes but is not limited to intellectual aptitude, legal acumen, contributions to legal scholarship. One of the cases that I will discuss, in one of the cases that I will discuss, the Macarubo case, the lawyer even claimed that he's the first lawyer who has been produced by his alma mater for secondary education. Ito na yan. Macarubo versus Attorney Macarubo. This is quite a funny case. Because in this case, the lawyer was disbarred for having 3 wives. While married to, while having a subsisting marriage, he entered into a bigamous marriage with another woman. And then after certain disputes with this second wife, he married a third. Ang gwapo ni Makarubo. In this case, he filed the petition for extraordinary mercy. This is very famous pleading. Kasi first time yan. Ang usual, petition for the institution to the practice of law. Pero in this case, ang final niya, petition for extraordinary mercy. Now, he filed this petition for extraordinary mercy 8 years after he was disbarred. He submitted to the court pictures as evidence that he asked for forgiveness from his children and wives. One of the lawyers who discussed this case when I was still a law student shared with us that this person has a family picture na andun yung 3 niyang asawa, andun yung lahat niyang mga anak. Ayun, in rereading this case, I did not find that fact. Pero meron siyang pictures with his children and the second wife na isinabmit. Who was the one who actually filed the case? Now, in his claims for reinstitution, he submitted a certification from the National Bureau of Investigation that he has no criminal record or that he has not even been accused of a crime. It's because hindi nag-file ng bigamy case eh. Di ba? Nevertheless, he was not accused of bigamy before the judiciary. Walang accusation, walang criminal record. In this case, umuwi siya sa sa hometown niya, sa Enrile. Anyone, anong province ng Enrile? Cagayan. Enrile, Cagayan. And he took care of his ailing mother. Nagplantito siya. And he served various government positions, including secretary to the mayor of Enrile, Cagayan. Now, his petition for extraordinary mercy is also supported by no less than the Integrated Bar of the Philippines, his chapter in Cagayan, and his former and present colleagues. Nag-present din siya ng attestation from a priest that he has been regularly attending religious services. Ayan, he claimed that he has already settled his marital squabbles. Diyos ko. Isang babae nga, hirap-hirap ng iapis. 3 pa kaya. Kaya siguro saludo din yung Supreme Court sa kanya. Ay, ang hirap. And The Supreme Court recognized his 14 years of dedicated service in the government. Hindi ko sinama dito pero inallege na rin that he is first lawyer who was produced by his alma mater in secondary education. And then the Supreme Court considered that he has productive years ahead of him because he's only 58 years old. Going by the evidence that he has presented, we see that he asked for forgiveness and he settled his marital squabbles, which showed remorse and reformation on his part, di ba? 8 years siyang disbarred, which is already a sufficient amount of time for reflection. Sana hindi nagdagdag ng fourth wife during that 8 years. Di ba, yung remorse and reformation, it must not only be proven by claims of any notable persons. Sabihin natin, sinabi ng IBP Cagayan na okay siya, ng mga abogado sa IBP Cagayan na okay siya. Sinabi ng parish priest na okay siya. Kulang yon. What is necessary are the allegations of these persons. You see, the allegations of IBP Cagayan and his colleagues there are a testament to his character that he is a good person. And as to his religiosity, we find that he has been regularly attending service. In the next case, ito yung sinasabi ko sa inyo, the Torres case. Ito yung napakasipag humingi ng judicial clemency. Okay. Ba't siya na-disbar? He presented false testimony. Alam niyo ba kung sino nakaaway niya? Sister-in-law niya. A family member. Kasi he had knowledge of forgery of a signature in a certain deed of extrajudicial settlement. Ito, dito inaayos yung mamanahin. At pinagkakitaan niya to. Now, right after he was disbarred, 2004, yes. Nag-file kaagad siya ng motion for reconsideration. 1. Matagal bago na nagkaroon ng decision for the first motion for reconsideration. Nung na-deny, nag-file siya ng second motion for reconsideration. You will find out later on in your remedial law review na pagka sa Supreme Court, one motion for reconsideration lang talaga dapat. Ang lakas ng loob niya na dalawa yung motion for reconsideration na i-final niya. As a result, the court issued a resolution that no further pleadings will be entertained regarding his case. By January 2006, nag-file na naman siya. I disregarded that decision that no further pleadings will be entertained. nag-file siya ng ex parte motion to lift disbarment. Di ba? Hindi na lang siya tumulad kay Makarubo. Kasi, kita mo yun na religious si Makarubo sa pleading niya pa lang eh. Petition for extraordinary mercy. Ito, ex parte motion to lift disbarment. Along with this ex parte motion, meron siyang personal letters na ipinadala kay Chief Justice Panganiban at the time and Associate Justice Tinga. He was just pleading to them. Argumentum ad hominem. Maawa na kayo sa akin. Gusto kong maging abogado. The letters he wrote to the members of the Supreme Court have been expunged from the records. Improper conduct yun, class. Wag na wag niyong gagawin. Na susulatan niyo yung members of the Supreme Court personally. Ang daming na-disbar dahil sa. Of course, if it's regarding anything other than a case, edi okay. Hindi pa rin siya nagpatalo. This is what we call persistent. In June 11, 2015, bakit after 10 years pa rin yung number 5? Anyway, I'm sorry. Hindi ko na-edit yan ha. Okay, in June 11, 2015, nag-file siya ng petition for judicial clemency, which was also denied. But this case, the 2017 case, nag-file na naman siya ng petition for judicial clemency. Hindi siya natuto. Kung nag-petition for ano siya, extraordinary clemency, di ba? 2017 case eh. 2013 case yung ano, kay Makarubo. Hindi siya nag-update sa legal ethics niya. Pero mo, nag-file siya nung March 2017. 12 years, not 10 years ha. Tama ba? 12 years. Siguro, mas maganda yung pangalan ng pleading niya. Hindi pa rin siya makakalusot. Why? Okay, tapusin na lang natin pala hanggang sa next case. This is a curious case. The curious case of Benjamin Dacanay. Benjamin Dacanay has been practicing law for 28 years in the Philippines. But because he got a certain ailment, he went abroad for treatment. In order to avail free medical services for his treatment, he stayed in that foreign country and eventually became a citizen thereof. But after he was treated, he went back to the Philippines. Now, we have our rules for qualification of lawyers. Since Benjamin Dacanay lost or suspended his citizenship, can he still resume his practice of law upon reacquisition of his citizenship? Hindi automatic na pagka mabawi niya yung citizenship niya, pwede siyang mag-practice ng law. That is why he filed a petition for leave to resume practice of law before the Supreme Court. Now, the Supreme Court recognized that he did not essentially lose his citizenship, but his citizenship was merely suspended pursuant to Republic Act 9225. But the resumption of his practice is conditioned upon certain things. He must first update his payment of annual membership fees in the IBB. Kung gaano siya katagal abroad, babayaran niya back yung mga years na yun. He must pay his professional taxes. He must undergo MCLE. And then he must retake the lawyer's oath. With that, we end tonight's lecture.